Hello, everyone. Thank you for joining today. We are going to give this about one more minute to get a few last people to join before we kick it off. All right. Hello, everyone, and welcome to Asurint's latest webinar, Keeping Up with Compliance, Legal Updates for Q3 of 2025. As a quick reminder, the purpose of Asurint hosting these complimentary quarterly webinars is to keep employers and HR professionals informed of the latest background screening compliance updates and best practices across all industries, helping organizations stay compliant and protect their workforce. Today's expert presenter is Asurint's General Counsel, Kelly Uebel. Kelly will be introducing herself in just a minute, but before we begin, I want to give you all a quick introduction to Asurint in case you're new here and not familiar with who we are. Asurint is innovating the background screening industry. Our powerful, customizable technology, backed by subject matter experts and personalized assistance, helps you hire the right candidates every time and faster than ever before. With Asurint, professionals like yourselves can leverage faster background checks to reduce manual workloads, minimize compliance risk, promote a safer workplace, and drive insights that boost hiring and recruitment success without sacrificing comprehensive, complete records. I have a few housekeeping items to cross off before I turn it over to Kelly to provide you all with the latest compliance updates. This presentation will run for about 40 to 50 minutes, which includes additional time at the end for questions, so please feel free to submit your questions as they pop into your head via the Q&A function on your screen, or simply enter them into the chat, and we'll make sure to address them towards the end. At the conclusion of today's session, you will be receiving an email with a link to this webinar recording to rewatch later or share with a friend who was unable to attend today's live session. You will also be receiving a copy of our popular guide, 50-State Guide, Employment Background Screening Laws. This guide is a very broad survey of laws across the U.S. and is periodically updated by Kelly and her compliance team here at Asurint and is an excellent resource for you to share with your colleagues. Kelly has a slide referencing this at the end of this presentation for all of you visual learners attending today. And with that, thank you again, Kelly, for leading today's webinar. The floor is yours.
Great. Thank you so much, Ethan. I appreciate it. And welcome, everyone, and thank you for joining us today. As mentioned, my name is Kelly Uebel, and I'm General Counsel for Asurint. If you're new here, just a couple quick seconds about me. I've been with Asurint overseeing our legal and compliance teams for 8 years now, and have been in the background screening industry. I think this is year 14. I previously have served on the board of directors, including as chair for the Professional Background Screening Association, or PBSA, and remain actively involved in the association via the Government Relations Committee, as well as the Leadership Development Committee and the Finance Committee. So background screening is certainly my passion, compliance in particular. So I'm really glad to have all of you here today. So just a quick disclaimer, the information offered here is educational only, so nothing constitutes legal advice. As I like to say, although I'm a lawyer, I'm not your lawyer, and you'll probably hear me reference consultation with legal counsel many times throughout the presentation today. I always think that's a good idea and a good takeaway from this type of session. So bear with me. I know you'll probably hear that over and over, but it's really important to emphasize that. So in terms of the agenda, this will run similar to our other quarterly compliance webinars we've hosted. We'll start with an agency and legislative update. Then we're going to switch into a litigation update, and we have a few different flavors of litigation to cover today. So I'm really looking forward to that section. And then we're going to close with a broader view of drug testing, legislation, and litigation that's happened. Generally, we've stayed pretty focused on marijuana because that's where most of the action has been, but a couple new developments outside the marijuana space that I'd like to share today. As Ethan mentioned, I do have the Q&A and chat boxes open. I try to weave in responses to your questions during the section that we're covering that relates to the question. So feel free to pop them in there as we go. I will try to tackle them on the fly. If not, we will have some time after. I don't think this is going to run a full hour necessarily today. We are in summer and a lot of states are now out of session. So maybe a little bit lighter today, which is great for everyone's calendars. So if we should have plenty of time at the end, and whatever questions we don't get to for whatever reason, I will follow up with you via email after the webinar. So let's go ahead and get started with our agency and legislative actions. So we're going to start with Oregon today. Oregon passed House Bill 3187. It will take effect near the end of September, September 28th, 2025. And at first glance, you may think, how does this really impact background screening? But it is important to be aware of and to review your processes, because what this law does is it modifies the state's existing anti-discrimination law to prohibit the collection of age and date of birth, as well as any sort of attendance dates or graduation dates related to any educational institution. So think college, high school, law school, whatever it is, prior to completing an initial interview. And if you don't do an interview, then it can only be collected after a conditional offer has been extended. So those may be some fields, particularly the educational institution, education information, history, whatever you want to call it, may be a section, for example, on your employment application, or something that you require applicants to complete when they're applying for a job via one of your applicant tracking systems, for example. So for this law, if you have a process in place that collects this information and requires that collection before one of those instances, that's where you're really going to want to review the technology you use, the forms you use, and your process to make sure you're collecting this information at the proper time. There are some limited exceptions. The law does not apply if the information is required to affirm that the applicant meets any sort of bona fide occupational qualifications, just kind of a broad term there, and or if required to comply with any provision of federal, state, or local laws or regulations. So review those exemptions as well to make sure when and if this law will apply to you if you're hiring folks in Oregon. But again, review your collection practices, the technology or the paper that you may use, and when you collect this information that may also be necessary for the background check, right? Because usually if you're doing some sort of education verification, you need to collect their education history. So when does that happen? When do you collect the date of birth for the background check? So really, again, a good touch point on your process prior to September 28th for this law. Next, we're going to move to Allentown, Pennsylvania. So Allentown passed this anti-discrimination ordinance, and really what they did was they repealed what was in place and just completely replaced it. And I can't remember if it passed and went into effect the same day, but it was a very short window, and there was hardly any fanfare about it. And if you've attended past webinars with me, you've heard that kind of theme, right? Where you get a lot of notice generally on the state level of something happening. Usually they give you several months, if not a year plus, to comply and change your processes. But when you start to get to the local and county levels, that's where things can get passed and go into effect same day, within 30 days, and you may not even know about it until after the effective date. So local laws definitely can pose a bigger challenge for employers, just generally from an awareness perspective. But this law is in effect. It applies to any employer with one or more employees. So pretty much everyone that has any sort of hiring that's happening in Allentown. And today we're going to focus on the criminal background check impacts. So the ordinance essentially bakes in a mini ban the box law, if you will. And if that term is new to you, ban the box has been kind of a long-standing concept now, that really deals with regulating the timing of the criminal history question. And then you have fair chance laws that we talk more and more about these days that go far beyond just the timing of the criminal history question into the criminal background check itself, adverse action requirements, job solicitation language, things like that. So this Allentown ordinance is a little bit more light on the restrictions, so a little bit more akin to a ban the box law. And it prohibits criminal history inquiries on that initial employment application. It also prohibits requiring any sort of disclosure of criminal history until after initial interview. So that really means that you should be doing that criminal background check at the earliest after a first interview. I don't know many employers today that background check everyone that submits an application at this point. I think there's usually some sort of vetting and qualification. I know it's become more and more popular for employers to move to doing background checks after a conditional offer because there's many laws around the country that now require that in their fair chance laws. But depending on when you do your background check, just know in Allentown, it has to be after a first interview. Employers can include in a job advertisement that the applicant has to have a clean driving record or be able to pass a child abuse clearance. So if those are important qualifications for you, those can stay in your job advertisements. And really, from a consideration of criminal history perspective, you have to make sure that the conviction record relates to the individual's suitability for employment. And this is really language that we've seen in many other city and state level laws now, where the employer is really being instructed to review criminal records on that individualized basis. So while there's no prescriptive factors that Allentown included, which we have seen in other similar laws, and there's nothing that references delivering of any analysis to the applicant. It is something you may want to review, like what factors you want to take into consideration, what process you want to follow. Do you want to commit this to writing? That may be a good idea in the event you ever get challenged on following any sort of analysis process. So these are all really good items to work through with counsel. And the ordinance also cites to the need for employers to comply with Pennsylvania state law, which really should just be a given because you have to comply with state law, whether the city level ordinance exists or not. But it does make a call out there. A question came in: the background check after first interview, but not after the job offer. Absolutely, you can wait and do the background check until after the job offer. As I mentioned, that's become a lot more common for employers to wait to do the criminal background check post offer versus before. That's not required in Allentown. It is required under some other fair chance laws on the city and state level and other jurisdictions. We have a really helpful ban the box guide that stays updated that goes into a lot of detail on each jurisdiction that has this type of law. So I encourage you to check that out on our website. But yeah, you can do a background check after a conditional offer in Allentown. I encourage, if you're impacted by this ordinance, to view the ordinance in full because there are additional limitations around job advertisements, salary history inquiries. There's more extensive protected classes than there used to be. So it is a pretty comprehensive anti-discrimination ordinance, and there is a private right of action allowed once the city's Human Relations Committee closes a complaint. So there is a potential for private litigation for violations of this ordinance. And while we're on the topic of city level anti-discrimination ordinances, I just want to issue a reminder. We covered this in the last webinar, but the Minneapolis, Minnesota anti-discrimination ordinance is in effect as of tomorrow. So if you are doing any hiring in Minneapolis, make sure you've reviewed this ordinance. It's very broad. The ordinance touches more than just criminal history, but it did create a new definition of justice impacted status. And so the ordinance doesn't ban you in Minneapolis from considering criminal history information, but it does require you to consider whether any sort of adverse decision is reasonably based on the relationship of the conduct of the conviction with the ability for the person to perform the position. So again, more of that individualized assessment is required. And there are some further information that the ordinance advises, including several factors that you have to consider. So remember to review this Minneapolis ordinance as well if you hire there, and work on your compliance before tomorrow. Okay, Washington. So Washington passed Substitute Senate Bill 5501. It went into effect just a couple days ago. And it basically prohibits employers from requiring that a valid driver's license is a condition of employment or including a statement in job postings that an applicant must have a valid driver's license. And that last one is one that's probably relatively common for employers to include, whether or not it truly is a factor, just because there's a lot of generic language that tends to get thrown into job postings. There are exemptions. So, for any of my transportation folks on the phone today, if driving is one of the essential job functions or it's related to a legitimate business purpose for a position, those are the exceptions. And is essential job function defined is a question that just came in. I don't believe so off the top of my head, but I can certainly pop back into the bill and follow up with you after. But I don't recall seeing that. Doesn't mean it doesn't exist. I just don't recall seeing it. So be sure to review any job postings, job descriptions that you have where you think an exemption would not apply, to make sure you don't have any impermissible language included, and that you're not potentially kicking people out from being considered for employment if they don't have a valid driver's license, if that position does not fall into one of these exceptions. All right, everyone's favorite topic, AI. It's all anyone talks about these days. So we'll move on to the AI topic with this federal update, a couple state level updates. Probably will become a somewhat routine topic for this quarterly webinar series, because again, it's kind of all people talk about. So the White House just a couple days ago did release its AI action plan. And before I dive into this a little bit more, I just want to make a comment that the 10-year moratorium on state level AI regulations was removed from the One Big Beautiful Bill. We've continued to see state level activity, which again we'll cover in a second. And I still think it's unlikely that any federal legislation is going to be advanced on this in the near term, certainly. I think I mentioned this last webinar. But when PBSA, when we were last on the Hill earlier this spring, it was a topic of conversation we brought up with many of the representatives that we met with. And a lot of the feedback, at least that I know my group got, was pretty consistent in that there is so much going on. We haven't even been able to focus on what AI legislation would even look like, and that there's potentially a broad range of viewpoints that will need to be thought of for this type of law. It's similar to what we've seen on the data privacy front, where the federal level has really struggled to pass any sort of federal level data privacy legislation because there's so many voices, so many viewpoints, and it kind of becomes a stop-start item. And I think AI is probably going to follow that path a little bit longer. So with that said, the White House did release, the Trump administration released America's AI Action Plan, which follows up on one of his prior executive orders. And this really is a series of recommended policy actions. It's not binding upon any particular agency, but it does touch on a number of items like reliable access to power, including leveraging federal lands potentially for new energy sources and data centers. It focuses on leading international AI diplomacy and security, which arguably the US is a little bit behind, at least from a legislative standpoint, from like the EU, for example. But it also really focuses on accelerating innovation in the space. And there was a recent AI summit, and I was reading some of the news reports from it, and it really seems like the emphasis in President Trump's speech was really on removing regulations related to AI in order to allow tech companies to really drive that innovation. And in the action plan, it does state that federal funding, should not be directed to states with burdensome AI regulations. So I think what they're trying to do here is discourage states from passing really comprehensive legislation on the issue, which again, we saw originally it baked into the One Big Beautiful Bill. And so there are a small handful of states with AI legislation on the books now. So it'll be interesting to see what continues to happen on the state level. With all that said, states are still doing things. So Texas passed House Bill 149, which was signed by the governor. The official title is the Texas Responsible Artificial Intelligence Governance Act. Really rolls off the tongue there. And it goes into effect January 1st, 2026. The good news for employers is that the Texas legislature really deviated from prior proposals that had far worse language or just more burdensome language for employers, because it would have regulated the use of AI in the employment context a little bit more like what we've seen out of Colorado, for example. But instead, the bill that was ended up being passed just more broadly focuses on things like government oversight of AI development and use, restricting AI tools from intentional discrimination against individuals or any committing some sort of constitutional violations. So there's a lot of language in that realm. It creates like a sandbox for development efforts. There's no private right of action under this law. Enforcement's all with the Texas Attorney General. So certainly still worth reviewing from an employer standpoint, but not exactly the same clear-cut impacts like we've seen in other jurisdictions, including everyone's favorite, California. So California, we talked about this a little bit in last quarter's webinar, but the California Civil Rights Council did announce on June 30th that they secured final approval for their amended regulations that protects against potential employment discrimination resulting from the use of AI. And AI as a topic is addressed very broadly in the regulations. It includes algorithms, it includes definitions for automated decision systems. These regulations go into effect October 1st. While October sounds far away, I have seen Halloween stuff in stores already. So, mind you, October will be here before you know it. And so, a limited amount of time for employers to really look at this and try to come into compliance with this act or with the regulations. And really, some high level tips here. You really want to look at the definitions themselves and what constitutes an automated decision-making tool or system, and start cataloging what tools you are leveraging in your hiring, recruitment, and employment processes, including whether those are from a third party, like applicant tracking system, for example, or some sort of onboarding software or system, whether they're homegrown. Start asking questions from your providers, including your background screen providers. How are you leveraging AI, if at all, in your process? Because we want to make sure that there's not, going to be anything that runs afoul of these regulations. And I've mentioned this before, but there is still ongoing litigation that's worth a review. It's called Mobley versus Workday. And this is really focused on age discrimination, but it really has looked at some of Workday's baked in AI essentially that was kind of kicking out resumes from being considered. So a suit was filed saying, hey, this is leading to discrimination. This is a problem. And so that litigation is ongoing. And there's a ton of articles out there that do the case far better justice than what I just did as a high level summary. But definitely recommend looking into that. And also really understanding what sort of automation, if any, is involved in your processes that removes a human element entirely. And even if there's still a human element involved, it's important to understand the scope of these tools, because you need to be looking at these anti-bias audits and things like that as potential defenses. So This is something we could probably spend the majority of our time on, but just really want to highlight that this is where you need to spend some time if you're in California. All right, litigation. So we're going to start with a Fair Credit Reporting Act case. And this one's really interesting simply because of how long it went on. So the case was filed way back in August of 2013. It reached basically a final end in May of 2025 when the court granted final approval of the negotiated settlement. So nearly 12 years of probably time consuming and expensive litigation here. And I do want to note, it's always important to note, the employer did not admit any fault or liability as part of the settlement. So oftentimes cases settle, even if you feel you're right, just due to this time and expense of litigation. But the original complaint involved an individual who applied with the staffing agency back in 2011. And so the agency, and this is all the allegations, right? So according to the allegations, the agency told the plaintiff she would not be hired for the positions she was being considered for due to information on the background report. The person said, "Hey, can I have a copy of that report?" And the agency allegedly replied with, "I don't know if we can give that to you, but we'll look into it." And then about a week later, apparently gave her a copy of the report, but it didn't include a summary of your rights under the Fair Credit Reporting Act, that document that should be with every single report you send. And so the plaintiff filed this class action complaint claiming the agency failed to follow the adverse action requirements under the Fair Credit Reporting Act. The class consists of individuals who had a background check performed on them between certain timeframes and that had either a red or yellow flag due to information contained on the report. And so I haven't seen a lot of colored flags anymore being used. Generally, people have moved more towards terminology versus colors. But certainly it's common for people to use certain labels or scores or indicators, whatever you want to call them, as part of their adjudication so they know how the report was scored and how they are going to move forward next, right? And we've talked about that in past webinars as well. But the reason I'm calling this out is because the court determined that these people should be a part of the class because they had a red or yellow flag. So to the court, that meant that the class member was not placeable because of the background report due to that flag that was applied. So I think, this started way back in 2011. Things have changed a lot and employers have evolved a lot over the last 14 years in terms of their processes. So we see a little bit less of employer just didn't do adverse action, and it's more becoming some of the technical violations, if you will, of the process. So whether the report got sent with a summary of rights, that still has been an issue. We've seen cases that do bring in reference to adjudication terminology, and especially if you're applying anything that implies a final decision was made before the pre-adverse action letter is sent, like fail, ineligible, do not hire, a red flag, anything like that. So one place that I routinely recommend employers spend some time, including consulting with qualified legal counsel, is on adverse action and your adjudication terminology that you're using and how you're executing your pre-adverse action and your final adverse action letter administration. So really important to spend time on this because it is still a routine issue in litigation for employers. I want to move on to the Sheetz update. So again, calling back to last quarter's webinar, we talked about President Trump's executive order that rejects the use of the disparate impact theory of liability that has long been leveraged by the EEOC, including in its cases against employers that were brought based on the use of criminal background checks. And so the EEOC actually ended up moving to dismiss its lawsuit against Sheetz. And just as a reminder, the EEOC filed the suit in April 2024, alleging that the employer violated Title VII of the Civil Rights Act by disproportionately screening out Black, Native American, Alaska Native, and I think multiracial applicants via their criminal record screening policy and process. And they cited to a lot of data that showed that individuals in those categories tended to be ruled out more so than white individuals with criminal history were. And so they brought the lawsuit saying, hey, this is resulting in racial discrimination. So following this, an individual has moved to intervene in the lawsuit, and the motion to intervene cites to the EEOC's own investigation, and that investigation found probable cause for the suit to be brought. And the individual seeking to continue the lawsuit, he's a Black man who originally applied to work as an evening shift supervisor. And he started work prior to the background check completing, which, pause, always a risky practice. And we can talk about that another day, but that's always something to really think about whether or not you want to do that. But so a felony drug conviction came back in the background check, and then he was basically removed from employment. And so he's claiming, like, hey, look, I was working there. There were no complaints about my work performance. There was no individualized assessment performed to see if this criminal history was even relevant to the job I was doing. And again, I've been working in the role. He's also bringing claims under Pennsylvania's Criminal History Record Information Act, which is a state law I don't think gets talked about enough, because it is important. It's there. It's been around for a long time, but it does address how employers can use criminal convictions in employment decisions. So, a second sidebar: make sure to review that law if you're doing any hiring in Pennsylvania. Sheetz is currently fighting the motion to intervene, so the case is still ongoing. But it remains a case to watch. It demonstrates what we talked about. Again, that even in the absence of the EEOC's pursuit of this concept of disparate impact liability, states and the private plaintiffs bar is going to pick up these types of issues. And so I don't think this is the end of criminal history litigation. And in fact, we'll turn to the next case, which is a separate case. From one of the questions in the chat, what Pennsylvania law do we need to review? The one here, right here, the Pennsylvania Criminal History Record Information Act. Highly recommend spending some time just reviewing that law. Okay, sorry, I've been dealing with a little bit of a cold. So Walmart, they are facing another class action based on their use of criminal records and employment decisions. So this is separate from one we've talked about in the past, and the case citation's down there in the corner. But this class action complaint was filed in June against the retail giant with two plaintiffs who were former logistic workers. They're trying to represent the class. And both of these individuals worked at a Walmart distribution center through a contractor for several years. So, as alleged in the complaint, Walmart moved to bring these logistic workers basically in house as employees versus going through the contractor. So, they had everyone go through a hiring process essentially, which included a criminal records background check. And then following this process, these individuals, they claim they weren't rehired or they had their positions revoked based on their criminal records. And so the complaint is also claiming that Walmart retained non-Black workers that had criminal records. And so these practices resulted in racial discrimination. And again, it's a more challenging place for a company to be in. And this is, I guess, part going back to my first sidebar on the last slide of, when you start someone at work before the background check is done, it does make it a little trickier, not impossible, but trickier to then remove them from the position, especially depending on what jurisdiction you're talking about, from the position, because arguably they've been doing the job potentially for weeks without having any sort of issues, right? And so if you're really looking at kind of that individualized assessment and suitability for the role, can they do the role even though they have this criminal history? That kind of makes it a little bit more challenging. And so it's important to look at your adjudication processes. So why are you potentially ruling people out for criminal history? Do you employ any sort of individualized assessment process across across every position, regardless of jurisdiction, or are you only doing individualized assessments where a state or local law has told you need to? Now, remember the EEOC's guidance from 2012 recommends individualized assessments or says that that's a practice they're looking for. And that's really where we started to see employers move away from any sort of blanket bans on criminal history, unless there's like a federal requirement, for example, that you can't hire someone with a certain criminal record. And so again, really, really important to look at how you're ruling people out for criminal history in this day and age. And I know I sound like a broken record to those longtime listeners out there, but investing now in a legal review of your program can potentially save you some money, time, and hassle later on. As we've seen, litigation can go on for a long time. It can be very expensive. And we know criminal background checks are an incredibly important part of the hiring and evaluation process. So again, really thinking through how you can use that information in a more individualized way to show that you considered those individual circumstances in relation to the position versus just saying something like, hey, we don't want to hire anyone with a felony. And so really spending some time on that will be important. To address a couple questions in the chat, I don't think there was any issues on co-employment alleged here because the contractor was basically removed from the equation, and then these folks came through Walmart as Walmart employees. But it seems like the lawsuit's generally focusing on the retailer. Okay, so California, so basically another quarterly webinar, another Fair Chance Act settlement announced by the California Civil Rights Department. I think we've included a new one every time thus far. So California, and what I've heard from folks in the industry and from some employers I've spoken with, the Civil Rights Department is very active when it comes to the Fair Chance Act. So really important to look at the Fair Chance Act and make sure you're buttoned up there. But in this case, a private healthcare college allegedly violated the Fair Chance Act by revoking a job offer based on criminal history information that you can't consider, which was dismissed convictions, dismissed charges. So the college allegedly also failed to take into account any evidence that was provided by the applicant that challenged the accuracy of the criminal history information. And so again, an important part is really taking into account anything the applicant gives you and considering that as part of your process, your evaluation process. So the settlement, of course, included a monetary amount, $63,500 in compensation to the applicant. It also requires the college to modify its employment practices to ensure they comply with the Fair Chance Act, including a commitment to not consider convictions that have been dismissed. As a standard, a company like Asurint does not report dismissed records. So if you use other providers, it's good to check in with them on what they consider to be reportable or not reportable, and what their reporting standards are. It also requires them to submit to monitoring for 2 years of all job offers that it revokes based on an individual's criminal history. So that's a lot of ongoing oversight. And provide training on the Fair Chance Act to any staff with a role in hiring. And this training component is something we've seen in these recent settlements that the Civil Rights Department has put out there. There generally has always been a training component. And we've emphasized training in the past as well in past webinars. Routine ongoing staff training is really more important than ever. So if you have folks that are involved in the hiring process, the background check review process, and you're not providing some sort of initial and then potentially ongoing training, I think you're opening yourself up to some potential risk. So that's where, maybe a good idea to talk with legal counsel about what does a good training program look like? What kind of routine should we follow? Should it be annual, every 2 years? How do we document and have them sign off the fact that they've received this training? How do we follow up on the training? So if you haven't thought about a training program internally, I think that's another really good area. And I know we're all really busy and I'm giving you a lot of action items here to think about. But that's potentially a good area to look at. And it could be something you're able to execute without a huge lift or a huge monetary investment. That can really help your staff remember the obligations that they have in looking at background checks and provide you with some potential defenses. So I think that's a really good area to spend some time on. The last issue I want to highlight here, it's not a lawsuit, but I wasn't quite sure where to put it. So it fell in this section of our webinar today. And this is starting to be picked up in local state news, but it deals with an issue that's really serious and it highlights concerns about fingerprint-based checks in particular. And so this individual was working at the school district for nearly 3 years. But prior to working there, he was indicted in 2021 or arrested in 2021 and then indicted in May of 2022 with some pretty severe crimes against children that, in my opinion, would have been disqualifying for a position within a school. But he was hired on as the assistant wrestling coach in October 2022 and then worked as a tech support specialist for a while after that before he was removed from employment. And he was recently convicted and received a pretty significant prison sentence for these charges. Now, according to a local news article, the school did follow its normal protocol, and state law in this state requires, I think it's Mississippi, requires public school districts to use fingerprint based background checks. So they submit the checks to the state's criminal information center. It's managed by the state's Department of Public Safety, and then it's checked against the Mississippi Criminal History System database. And then if nothing hits there, like any sort of felony conviction or anything like that, it goes to the FBI for a quote national database check. So to me, this still highlights a huge issue with these types of checks because FBI background checks have long been mistakenly viewed as the gold standard, when in fact there are a lot of deficiencies with an FBI fingerprint search, which first of all can only be conducted if you have a state or federal statutory requirement to do so. But some of these state fingerprint databases have some of the same deficiencies as the FBI. First of all, you have to be fingerprinted to have a fingerprint based record, right? And not every crime gets fingerprinted, although apparently in this case, he was fingerprinted. And so what we've seen employers do, or kind of what I've also recommended to employers in this scenario, is that if you're legally required to do an FBI fingerprint check or a state database fingerprint based search, don't end there, right? It's still important to perform a more comprehensive background check as you would on potentially your other employees that don't have this particular requirement, such as looking at various county level searches, still developing your address history and running criminal searches based on that address history versus just relying on one state fingerprint based search. That way you have a little bit more of an assurance that the more thorough screening has been performed to potentially locate any records that, again, maybe didn't have fingerprints associated with them or were not reported into the FBI or state database. And, it's a little fuzzy exactly as to what happened here. They claim he was fingerprinted. They claim it should have been in the database. It sounds like they weren't really sure why it didn't come back with the state search. But perhaps, and I'm not saying this is true, but perhaps a county level search or a different version of a criminal search could have potentially found these charges and prevented this person from being in a position that arguably they shouldn't have been in. And so really, again, just want to highlight some of the things you need to think about as you work through some of your more regulated roles, if you have any, that may have very specific background check requirements. All right, we're going to close out today with drug testing. And I know I said this is going to be a shorter webinar, but I have now rambled on for 45 minutes. So we'll wrap up drug testing here and still leave a little bit more time for questions. But on the federal level, still not a lot going on. Terry Cole was sworn in as administrator of the USDEA. I think that was last week. And he had a press release that highlighted the news. And there were several strategic priorities referenced, such as dismantling the Mexican cartels, reducing drug-fueled violence, kind of the usual suspects, right? But the press release did not include marijuana rescheduling efforts in the list of strategic priorities, which seems to have caught some people off guard because he claimed during his confirmation hearings that would be one of his first priorities. So stay tuned still. It seems like this is kind of continued to fall down the list of priorities under the Trump administration thus far. Unclear what's going to be happening next. But if this is a topic important to you, kind of just one of those ones you still have to watch for now. Going to move to Iowa. Iowa House Bill 767 went into effect at the beginning of this month. And this amended Iowa's drug testing law in a way that allows employers to offer the opportunity to current employees to receive notifications related to the positive drug tests for in person or through electronic means. And this is great because previously the notification had to include, which has to include the results of the test along with their right to request a retest. So there's kind of the contents of the notification are the same, but the notification used to have to be delivered via certified mail, return receipt requested, which is kind of an onerous process in this day and age. And so a little bit more of a friendly, timely communication allowed between the employer and the employee here. New Mexico. New Mexico Senate Bill 219. It's technically in effect, but they don't expect it to be fully implemented until the end of the year 2027, which does sound like a long time from now, but I'm sure it'll be here before you know it. And this is essentially legalize the medicinal use of mushrooms. So they do feel, according to the New Mexico Department of Health, that this legislation will establish a regulated program for the medicinal use of these drugs, and they can be used to treat qualified medical conditions such as PTSD, substance use disorders, end of life care. They are working on developing rules and regulations to govern this program. At this time, there really aren't any requirements, for example, for employers to accommodate use of this in the workplace. But a good idea to stay on top of the rules and regulations if you're in New Mexico, just to see how it may impact the employment space. And then our last state update here, Pennsylvania, and then I do have a really interesting drug testing case coming up, so don't drop yet. But Pennsylvania still working to legalize recreational marijuana. One of the more recent examples is House Bill 1735. There's been several other proposed bills. 1735 was referred to the Health Committee on July 16th, kind of unclear if it'll move forward or not. As currently drafted, there is language addressing employers and employer liability. It would still allow for drug tests and decisions to be made on those drug tests. But worth keeping an eye on the efforts in Pennsylvania. I've read some articles about just the topic generally in that state, and it's still a pretty hotly contested subject. Where some people don't think it should move forward. Some people really think it should move forward. Some people differ on how it should move forward. So it's still kind of up in the air in Pennsylvania. Okay, our last topic of today, Minnesota. So Minnesota District Court recently issued a ruling. I think this was from May, and it deals with Minnesota's Drug and Alcohol Testing in the Workplace Act, which is one of the strictest drug testing laws in the state. And it's recently been amended and modified to accommodate some of the marijuana law that has happened in Minnesota. But this case in particular involves an employer who's regulated by federal law, including DOT regulations, to establish and maintain a drug and alcohol testing program. And so all employees were subject to its broader drug and alcohol testing policy, but only employees in safety sensitive positions and who performed covered functions as defined under applicable law were subject to random testing. So DATWA, as I like to call it, does deal with random testing. It's kind of difficult to drug test people in Minnesota, I would say, but sidebar, you should really review this law if you're drug testing in Minnesota. But so anyway, on a monthly basis, in this case, the covered employees were selected for random testing. Certified lab was used because there's a lot of requirements around how the drug test should work. If the test was positive, they were immediately removed from the safety sensitive position and suspended pending a further investigation. And then if there was no satisfactory reason as to why they tested positive, they were terminated from employment. And so the plaintiff in this case was working as a gas distribution system engineer who's part of a bargaining unit covered by a collective bargaining agreement that included drug and alcohol testing procedures. And due to his position, he was randomly selected for a drug test. And so the initial and confirmatory tests on one of the two vials he filled both tested positive for marijuana THC. And so an MRO called the plaintiff, gave him a chance to ask questions, gave him a chance to request a test on the second vial he filled. Apparently he declined, and so he was then suspended and later terminated. And so eventually it led to this lawsuit getting filed. And he claimed that the employer did not comply with DATWA by basically failing to provide a drug policy on the day of the test, didn't ask him to acknowledge in writing he reviewed the policy, didn't inform him in writing that he could request a retest, didn't permit him to participate in drug counseling or rehabilitation after receiving the results. And so, a lot of claims under the state's drug testing law there. And so that brings us to the present motion on summary judgment, which was filed by the employer, and that's what this court ruling is on. The employer said this case needs to be dismissed. Minnesota state law is preempted by the requirements we need to comply with under federal law. And the court agreed. It agreed with the employer and dismissed the case. And the court pointed to Minnesota's own deferral to federal pipeline safety regulations. And since the state applies the regulations of the DOT and its operating agency, the court found that the DOT regulations preempt state law, which is something we've talked a lot about in general when we talk about marijuana specific legislation. But this is broader than marijuana. Further, the court determined that the state's drug testing law includes a preemption provision, noting that it doesn't apply to employees who are subject to drug and alcohol testing under federal regulations that specifically preempt state regulation. And so again, because this employer and this position were covered by these DOT regulations, state law was expressly preempted, and compliance with both federal requirements and the state law here was either impossible or it was an obstacle to the accomplishment and execution of DOT requirements. And so the whole case in general, it's worth a read. If you have regulated roles in your organization and you do any hiring in Minnesota, even if you're subject to different federal or DOT regulations than the employer in this case, but really, to ensure your program is established properly to accommodate your federal requirements first and foremost. Also worth just revisiting your policies and procedures as it relates to Minnesota state law, given the extensive nature of the law. And as a reminder on Minnesota's state law, the state drug testing law now requires employers to provide written notice to employees or applicants at least 14 days before you take any sort of adverse action against them based on a positive cannabis test. So really, really hard and slow to take action against folks for positive marijuana tests now in Minnesota. But the written notice is there's very specific requirements. It has to cite to the specific federal law regulation that you believe you'd be violating. If you fail to take action, it has to specify what monetary or licensing related benefit under federal law regulations you may lose if you fail to take action. So really, you need to spend some time on these recent amendments to DATWA, in addition to the law itself, because it's pretty extensive. So with that, we have reached the end, and I've tackled a lot of the questions in the chat thus far. I know there was a question about the hyperlink to the California regulations, so I can send those to you via email after this if anyone else wants a copy of any of the cases we referenced or the regulations we referenced beyond the hyperlinks or case citations that were shared. Just feel free to reach out. We're happy to provide that information. I think one of the last questions. Uh, if it wasn't a DOT covered role, even for a covered employer, would this still have the same finding? I don't know if I have a solid answer for you on that. I think, this case was so specific because the position was regulated by the DOT. It was the employer had a really well thought out policy, a well communicated policy, it was trained on, and it wasn't one policy applied to every position. The company seemed to put a lot of thought and effort into the rollout and execution and ongoing compliance with their drug and alcohol workplace policy. So I think that was helpful for them as well. So always worth reviewing those policies and practices. Okay, as mentioned, you will receive a copy of the recording as well as our 50 state guide. It has been updated to reference some of the things we've talked about today, like Allentown, for example. And for any of you who may be attending any of the following events on this slide, please make sure to stop by the Asurint booth to say hello. You can grab some of our new swag, enter some of our giveaways to win some great prizes. And of course, encourage you to follow us on our socials, LinkedIn, Facebook, X/Twitter. I guess I'll forever call it Twitter. And give us a follow because we do post a lot of our ongoing updates there as well. And yeah, I really appreciate everyone for attending today. Thank you for your time, and I hope you have a great rest of your Thursday.